So let us continue with our discussion. I think we ended the discussion last time with Rule 112, Section 3. Okay, we are still in the procedure of the preliminary investigation. But we are, I think, no, we are already in Section 4. Tama ba? Okay. Yeah, I remember. We are already in Section 4. And this is the time when the investigator has already resolved. Okay, so ano yung mangyari if there is already a resolution, if the investigating prosecutor finds cause to hold the respondent for trial or does not find cause to hold the respondent for trial. Okay, you also know that there is a need for that resolution to be approved by the boss. Remember, the provincial prosecutor, the city prosecutor, or the chief prosecutor, or the ombudsman or his deputy in cases of offenses cognizable by Sandigan Bayan in the exercise of its original jurisdiction. Okay? In fact, we have learned that the boss can reverse the decision or the resolution of the investigating prosecutor. Okay? Without without necessarily um, directing the investigating prosecutor to revise it, because under the rules, pwedeng by himself, the boss can file the information against the respondent or direct any other assistant prosecutor or state prosecutor to do so. But when he does that, um, there is no need for another preliminary investigation. Now, what if you are the one of the parties in the preliminary investigation and you are not satisfied with the resolution issued by the prosecutor? What is now your remedy? Your remedy is to file a motion for reconsideration before the office of the investigating prosecutor that conducted the preliminary investigation. How many days from the time that the party received the resolution can he file a motion for reconsideration? 15 days. Okay? 15 days. Now, if after the motion for reconsideration, the investigating prosecutor still affirmed the previous resolution, meaning to say he did not reverse, he did not modify or make any changes in the previous resolution, then what is now your remedy? Your remedy is to go to an appeal. Okay? So before you go for appeal, my advice is you file a motion for reconsideration. And if still hindi pa rin tumalab, then that is the time that you go for appeal. Okay? So how many days from the time that you receive the resolution of your motion for reconsideration, how many days can you file your appeal? You can file an appeal within the 15-day period from the moment you receive the resolution of the investigating prosecutor. Okay, so my advice really is before you go for an appeal, you you resort first with a motion for reconsideration. And if the investigating prosecutor still affirms the resolution, then that is the time that you proceed to an appeal. Now, I told you also last time that the last paragraph of section 4 is no longer applicable. This is already amended by the DOJ circular, DOJ circular number 27, which was issued by the Department of Justice last July 13, 2022. Okay? So here, the appeal is by petition for review. That's what you file whenever you do an appeal. Appeal from where? Appeal from the investigating prosecutor. Okay? So, na-deny pa rin yung motion for reconsideration mo. So, that is the time that you go for an appeal. And when you do so, you file your petition for review. That's the pleading that you will file whenever you do your appeal. Okay, are you still following, class? Ha? For a while, ha? Okay. Now, ano ba ang sinasabi ng DOJ Circular number 27? Here, the petition for review must be filed. Okay? Where? It depends. Okay? It depends kung saan siya or kung anong case ang involved sa kaso na ito. So, if the case involves an offense that falls within the jurisdiction of the RTC, okay, you go back to your jurisdiction, more than 6 years, di ba? So if the crime involved is punishable by more than 6 years of imprisonment, then that's RTC jurisdiction. So if that happens, where will you file your petition for review? You file it before the office of the DOJ secretary for the appeal of the preliminary investigation. Now, other than that, if the case was initiated upon a referral by the government agencies, like for example, it's the NBI that filed it or the PNP that filed it to the prosecutor and then dinismissed ng prosecutor despite the filing of the MR, denied. So, ngayon, ang remedy ng NBI or ng PNP is to go for an appeal. Okay? So, where will you file your appeal? In the first place, ano yung ifa-file kapag mag-appeal? It's the petition for review. Now, where will you file your petition for review? You file it before the office of the DOJ secretary. The petition for review should be filed with the Prosecutor General if the preliminary investigation involves an offense that falls within the jurisdiction of the MTC in the NCR. Meaning to say those which are punishable by by 6 years and below. Okay, so if that is the case, where will you file your appeal? Before the office of the Prosecutor General. Now, how about if outside the National Capital Region? Where will you file your appeal? And that involves a case under the jurisdiction of the MTC. So the petition for review should be filed with the proper regional state prosecutor. Okay? Doon mo ifa-file yung petition for review mo. The resolutions of the Prosecutor General and the regional state prosecutors in those cases are no longer appealable to the Secretary of Justice. Okay, so please take note of that. Kapag ang case is punishable by, is within the jurisdiction of the RTC, or if it is initiated by NBI or PNP, and then dinismiss or not favorable sa iyo yung resolution ng prosecutor, ng investigating prosecutor, then you file your MR. Kapag denied pa rin, then you go for an appeal. And when you do na appeal, you file the petition for review. Ang question na lang ngayon is saan mo ipa-file ito. So if it is a case punishable or under the jurisdiction of the RTC or initiated by the PNP or NBI, then you may do your appeal before the office of the DOJ Secretary. But if it is not, then kapag nasa National Capital Region ka, you file your appeal, you file your petition for review before the Prosecutor General. And if it is outside NCR, then you file it before the Office of the Regional State Prosecutor. The decision of the DOJ Secretary in terms of, in the case of RTC cases, or the decision of the Regional State Prosecutor or the Prosecutor General are final, okay, and no longer appealable. So, what if hindi pa rin favorable sa iyo yung decision ng Prosecutor General or ng Regional State Prosecutor or ng DOJ Secretary? What will be your next step? Then, because wala nang other appeals, okay, you can do your petition for certiorari under Rule 65. Okay? So, certiorari ka na sa Rule 65. That is a new case. That is not an appeal, but that is an initiatory action. Okay? So, that is the remedy there. So, should you have any questions regarding this matter, please drop your question on the comment section so that we can address them. Okay? So, in the meantime, let us proceed to section 5 or section my unit is not cooperating with me. Okay, let's go to section 5. Now, section 5, resolution on investigating judge and its review. This is no longer applicable to us. So we skip this and let's proceed to section 6. Okay? So remember that section 5 is about resolution of investigating judge and its review. And wala na pong power ang judge na mag-conduct ng preliminary investigation because again, we have already resolved that preliminary investigation is purely an executive act. Since a judge is a personnel of the judiciary, that is no longer within his purview. He cannot exercise a preliminary investigation. So we go to section 6. Okay, we are still in Rule 112. Section 6, when warrant of arrest may issue. Okay, so there are section 6 and section 7 are related. Okay, and basically, before we talk about arrests, okay, the question there is, paano ba natitrigger ang pag-issue ng warrant of arrest? Okay? It's triggered by the resolution of the investigating prosecutor and it becomes final, then it will be transmitted to the court, either in the NTC or in the RTC. Once the court receives it, then the next thing to do is observe Rule 112, Section 7. So when a person, okay, Section 6, let's start with Section 6. Sa RTC tayo una. Okay? Within 10 days from the filing of the information, okay, remember that once there is probable cause, ano yung i-issue ni judge? ng investigating prosecutor, it's the resolution plus the information. And this information will be transmitted to the court, either in the RTC or in the MTC. But actually, it's not only the information. Nandyan rin yung kopya ng kanyang resolution at saka yung kopya talaga ng case. Matatransmit yan sa korte. Okay? So once the case record is transmitted to the court, the judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. Kaya nga, ang buong records matatransmit kasi ito yung sabi ng Rule 112 Section 6 na ang judge mismo shall personally evaluate the resolution of the prosecutor, which is found in the resolution, and its supporting evidence, which are found in the affidavit complaint, in the what else? In the counter affidavit, in the affidavits of witnesses. So, i-review yan. The court may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. Okay? So, even if sabihin ng prosecutor that there is probable cause, ang sabi ng Rule 112 Section 6, if the court sees, okay, or deems it that there is no probable cause, then immediately pwedeng i-dismiss ng judge. If he finds probable cause, he shall issue a warrant of arrest. Actually, class, I have a problem with this part. He may immediately dismiss the case if the evidence on records clearly fails to establish probable cause. Although, I am still waiting for the court to make a further discussion on that part, considering that there is already a move that the judge has no power to conduct preliminary investigation. Because it seems that if sabihin ng fiscal that there is probable cause and then the judge will immediately dismiss it when there is no probable cause, para pa rin nag-exercise ang judge ng preliminary investigation, which sabihin na nga natin, walang power ang judge to do that because that is purely an executive function. Okay? So just put an asterisk on that part, and if we can find a jurisprudence or a discussion later on before you take the bar, then at least we have resolved that portion. Okay? In the meantime, let's just follow what the caudal or what the rules is saying, that the judge may immediately dismiss the case if the evidence on record clearly fails to establish probable cause. Okay? But if he finds probable cause, meaning to say, if he confirms the decision of the resolution of the prosecutor, then what will the judge do? And this is usually what happens in practice kapag na-receive na ng court yung kopya or yung record ng case and talagang may probable cause sa resolution ni fiscal, usually, ang ginagawa ni judge is he shall issue a warrant of arrest, okay, or a commitment order. So, it could be that the judge will issue a warrant of arrest or a commitment order. These are two different documents. These are two different issuances. Warrant of arrest is the general rule. But commitment order is proper if the accused has already been arrested pursuant to a warrant issued by the judge who conducted the preliminary investigation. This part is no longer applicable again. But commitment order is still practiced right now when the complaint or information was filed pursuant to Rule 112 Section 7. That is when there is a warrantless arrest. Okay? In case of doubt on the existence of probable cause, okay, the judge may order the prosecutor to present additional evidence within 5 days from notice, and the issuance must be resolved by the court within 30 days from the filing of the complaint or information. Again, this portion is no longer observed. Because again, kung ano yung sabihin ng prosecutor that there is probable cause and it's final na doon sa preliminary investigation, the judge can no longer reverse the the decision or the resolution in the preliminary investigation, because again, preliminary investigation is purely an executive act. Okay? So dahil naging final na yun siya, the judge is nothing to do but to issue either a warrant of arrest or a commitment order. Warrant of arrest kapag hindi pa na-aresto. Okay? Commitment order is kapag na-aresto na yung accused because of a warrantless arrest. Okay? So, yan. In the MTC, ganun rin. Once there is a resolution indicting the accused or indicting the respondent, kapag na-indict na ang respondent, there is a probable cause, then the respondent now turns to become an accused. Okay, from respondent, dahil meron ng information, kasi nga merong probable cause, the respondent becomes an accused. He is now accused by the prosecution. Okay? So, sa preliminary investigation, yes, respondent pa siya. But again, after the preliminary investigation and he is indicted, he is being charged because there is already a formal charge, there is an information, then the respondent is now known as the accused. Okay? So, yan. Now, let me check ha. Baka may na-miss out ako. Now, paragraph C of section 6, when warrant of arrest is not necessary. A warrant of arrest shall not issue if the accused is already under detention. So meaning to say, before pa umabot yung case sa court, na-detain na yung accused, could be because of a warrantless arrest. Okay? So, yan. And then, if the complaint or the information was filed pursuant to Section 7 of Rule 112, that is one of the reasons why warrant of arrest is no longer necessary. So if that is the case, ano yung ini-issue ng court? It's the commitment order. Kasi there's no point of arresting the person who has already been arrested. So what the court does is to issue a commitment order. But if hindi pa siya na-aresto or hindi siya inaresto, and the resolution and the information has already been filed, is it possible for the accused not to be arrested even if it is a criminal case? The answer is yes. Ang sabi ng Rule 112 Section 6, if the offense is only penalized by a fine only, walang imprisonment, then there's no point for you to issue a warrant of arrest. Hindi rin commitment order kasi nga hindi siya pwedeng i-detain. Fine lang kasi ang punishment. Okay? The court shall then proceed in the exercise of its original jurisdiction. Okay? So, sabi natin kanina na posible na while conducting the investigation or even before the investigation commences, the respondent is already arrested. Even if hindi pa siya accused, he is already arrested. And why is that? Rule 112, Section 7. When a person is lawfully arrested without a warrant, meaning to say warrantless arrest ang nangyari, involving an offense which requires a preliminary investigation, you go back to your Rule 112, Section 1 and Rule 110, Section 1. Okay? The complaint or information may be filed by a prosecutor without need of such investigation provided an inquest has been conducted in accordance with existing rules. Ano bang ibig sabihin yan? Ibig sabihin, dahil naaresto na po yung respondent, wala pang formal charge pero naaresto na siya um, because of a warrantless arrest procedure which we will learn later on. So, hindi na magkakandak ng preliminary investigation as a general rule kasi nga nasa detention na po yung accused. Instead, ang sabi ng rule is that the fiscal or the prosecutor will conduct the so-called inquest proceeding. Okay? So an inquest proceeding is the proper procedure that the investigating prosecutor must do instead of conducting a preliminary investigation because the accused or the respondent is already detained. Okay? So kapag na-detain na po yung respondent, there is no preliminary investigation there as a general rule. Kasi ang gagawin ng prosecutor is to conduct an inquest procedure. Okay? In the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Before the complaint or information is filed, the person arrested may ask for a preliminary investigation in accordance with this rule. This is the exception. Because supposed to be, you have already been detained dahil walang warrant and you were caught in the act, for example, so you were arrested. Supposed to be what the prosecutor should do is to conduct an inquest proceeding. It's more summary than preliminary investigation. Wala nang affidavit complaint dito or wala nang counter affidavit na gagawin. Okay? Yes, there is still an affidavit complaint to be filed before the prosecutor, and the prosecutor will conduct immediately an inquest proceeding. Pero the prosecutor will no longer ask the respondent to file his counter affidavit and the respective affidavits of witnesses kasi nga nasa kulungan na po yung respondent. So what the prosecutor will do kapag na-detain na yung respondent, hindi pa siya naging accused, kandakan na ng inquest proceeding. It's a summary procedure to determine whether or not there is a probable cause to indict the respondent. Okay? But possible ba na sa ganung sitwasyon, possible ba na mag-conduct pa rin ng preliminary investigation? The answer is yes. That is the exception. General rule, dapat what we should observe is the inquest procedure. Kaya lang, exception is that there could still be a preliminary investigation even if the respondent is under detention if the respondent or the person arrested asks for a preliminary investigation in accordance with the rule. But remember, if you remember your Article 125 in the Revised Penal Code, Crim 2, okay? Hindi pwede kasi na nakulong yung isang tao na walang formal charge. Okay? So, ang formal charge lalabas lang yan kapag merong preliminary investigation or kapag merong inquest proceedings because a formal charge is based on the information that is being filed by the prosecutor. Kaya lang, remember that merong number of hours from the time na na-detain yung tao, merong number of hours na binigay ang Article 125 of the Revised Penal Code para mag-file ng information. Kapag hindi mo yan na-file, kailangan mo nang palabasin yung detained person. You know that? Are you familiar of Article 125? Familiar? So meaning to say, from the moment that you are being detained, tumatakbo na po yung oras na sinet ng RPC or ng Revised Penal Code, Article 125. Okay? Although you have learned in your cream 2 na meron yan siyang proper counting. Okay? Hindi yan siya tatakbo kapag holiday or kapag Saturday walang office, because that would be unfair also on the part of the prosecution that you will count it as a running period. Hindi. It will commence to run from the time that you are arrested and kapag merong office. Kaya usually, ang takot talaga dito is kapag nakulong ka na kinabukasan na holiday, and long holiday pa talaga kasi hindi pa tatakbo yung number of hours na sinet ng Article 125 of the Revised Penal Code. Okay? So again, kapag na-detain ka, okay, walang holiday, weekdays, na-detain ka, tatakbo na yung oras ng nasinet ng Revised Penal Code, Article 125. Okay? So within that particular period, dapat naka-investigate na ang prosecutor and dapat nakapag-issue na ng information para formally ma-charge yung respondent. Okay? Otherwise, if walang formal charge na nangyari, okay, within the period set by law, then the arresting officer must release the respondent. Otherwise, the respondent or the police will be liable against Article 125 of the RPC. Okay? It's a crime. Now, what if na-detain ka? Warrantless arrest. Tumatakbo na yung period na sinet ng Revised Penal Code. Okay? Supposed to be, ang gagawin sa iyo is inquest proceeding. Kasi nagmamadali nga tayo eh. Okay? Kasi limited yung time na binigay. The reason here why inquest ang gagawin because the procedure will be summary in order to beat the deadline set by Article 125 of the Revised Penal Code. Ngayon, what if gusto mo talagang mag-conduct ng preliminary investigation? And preliminary investigation, as we all know, will take us time because we will file our counter affidavits, we will file the affidavit of witnesses. Maraming proseso po kasi. So, kung gagawin natin yan, talagang lalampas tayo doon sa number of hours na sinet ng Article 125 of the Revised Penal Code. So, how do we resolve that? Pwede ba nating i-prohibit ang respondent na nasa kulungan na mag-request ng preliminary investigation? The answer is no. Okay? So meaning to say, this is an exception to the rule. Kasi general rule, kailangan inquest lang kasi summary dapat in order not to violate Article 125. Pero kapag ang respondent na mismo ang nag-request na mag-preliminary investigation, jud ko, okay? Then, under the rules, that could be allowed. However, the respondent must sign a waiver of the provisions of Article 125 of the Revised Penal Code as amended in the presence of his counsel. Okay? So meaning to say, that is a waiver na you will not file a criminal case against the police authorities. And hindi na natin i-matter or i-consider yung number of hours na sinet ng Article 125. Okay? Kasi nga, na-waive mo na yun kasi gusto mo nga ng preliminary investigation. Now, notwithstanding the waiver, he may apply for bail. Okay? So, pwedeng mag-apply ng bail ang respondent and the investigation must be terminated within 15 days from its inception. So, limited pa rin siya 15 days. After the filing of the complaint or information in court without a preliminary investigation, the accused may, within 5 days from the time he learns of its filing, ask for a preliminary investigation with the same right to adduce evidence in his defense as provided in this rule. Okay? So, ano bang ibig sabihin yan? Okay? Walang preliminary investigation na nangyari, this is the remedy. The accused may, within 5 days from the time he learns of its filing, ask for a preliminary investigation with the same right to adduce evidence in his defense as provided in this rule. Okay? Now let's go to Section 8. Records supporting the information or complaint. Remember that the information or the complaint are not the only documents that will be transmitted to the court. Diba? Information, affidavit, complaint, all the records actually are transmitted. So the information or complaint filed in court shall be supported by the affidavits and counter-affidavits of the parties and their witnesses, together with the other supporting evidence and the resolution of the case. In short, lahat ng records ang itatransmit doon sa court. The record of the preliminary investigation, whether conducted by, the judge is no longer allowed. So conducted by the prosecutor shall not form part of the record of the case. Please take note of that. I just realized that lately na saan na yung final? Saan na yung final na mga documents sa preliminary investigation? Bakit wala na siya sa court records? And this is the answer. Okay? Rule 112 Section 8 tells us that the record of the preliminary investigation shall not form part of the record of the case. Okay? So, even if we say na natatransmit yung records ng prosecutor doon sa court, but this tells us na hindi lahat ang natatransmit. Okay? Importante lang dyan yung information, yung resolution, yung mga affidavits, counter-affidavits, yan. And all the supporting evidences. But it is not a guarantee na 100% lahat ng records ng fiscal during the preliminary investigation is transmitted doon sa court because it shall not form part of the record of the case. However, the court on its own initiative or on motion of any party may order the production of the record or any of its part when necessary in the resolution of the case or any incident therein, or when it is to be introduced as an evidence in the case by the requesting party. So, kapag final mo yun sa Office of the Prosecutor, and diba, sabi nga natin, hindi lahat ng final mo dyan sa fiscal matatransmit doon sa court. Okay? But you want to use that doon sa court procedure. Okay? What can you do? Kasi hindi man siya part ng record of the case. You may file a motion or the court may motu proprio issue an order for the production of the record or any of its part when necessary in the resolution of the case or any incident therein, or when it is to be introduced as an evidence in the case by the requesting party. Okay? So, yan. Let us now proceed to Rule 112, Section 9. Cases, these are cases not requiring a preliminary investigation and they are not covered by the rule on summary procedure, which we will discuss also later. So, if the complaint, remember na general rule, kung hindi yan siya punishable by 4 months, 4 years, 2 months, and 1 day, there is no need for preliminary investigation, di ba? So, If the complaint is filed directly with the prosecutor involving an offense punishable by imprisonment of less than 4 years, 2 months, and 1 day, then is it possible na mag-preliminary investigation pa rin kahit less than 4 years, 2 months, and 1 day? The answer is yes. Rule 110 taught us that, Section 1, na kapag nasa Metropolitan Manila or nasa Metro Manila or nasa mga chartered cities, ganun pa rin, kahit less than 4 years, 2 months, and 1 day po. And once that happens, the procedure outlined in Rule 112, Section 3, Paragraph A, shall still be observed. The prosecutor shall act on the complaint based on the affidavits and other supporting documents submitted by the complainant within 10 days from its filing. Okay? If the complaint or the information is filed with the MTC for an offense covered by this section, then the procedure in Section 3A shall be observed. Um, this is no longer observed kasi nga hindi na nagkakandak ng preliminary investigation ang court. Okay? So, yan. Disregard that part. So I think that ends our discussion in Rule 112. Okay? So in the next meeting, we will proceed to Rule 113. Ito na po yung arrest. Okay? So please read ahead of time Rule 113. God bless everyone and have a good day.